We're going to have time for questions and back and forth from the audience, but we are going to have brief comments from our two other distinguished speakers to illuminate this whole issue of race and justice, racism and justice. Jerry Miller, who was due to be here today, has had a medical emergency, and I can only urge those of you who have not read his extraordinary books, Search and Destroy, and last one, Over the Wall, to seek him out through his words, and we send him our regards. Luckily, our stand-in for Jerry Miller tonight is our own Stephen Drizin, who's an attorney here for children at the Children and Family Justice Center in the Legal Clinic of Northwestern Law School. Steve is a lawyer on fire, a lawyer in the Clarence Darrow tradition. He represents children in juvenile and criminal courts. He is a passionate teacher. He is my teacher. He breathes life and fire into the law. He is a true meaning maker. Steve Drizin.
Good evening. Many historians trace the juvenile court, the children's court, movement in Chicago back to 1884, when a young lawyer, who later would become governor of Illinois, published a book entitled Our Penal Machinery and Its Victims. This young lawyer, who happened to be the law partner and close friend of Clarence Darrow, was named John Peter Altgeld, and his picture is outside of this auditorium, hanging among those who founded the first juvenile court. In his book, Altgeld described the criminal justice system as a great mill, which in one way or another supplies its own grist, a maelstrom which draws from the outside and then keeps its victims moving in a circle until they are swallowed up in a vortex. Getting caught in this maelstrom, according to Altgeld, was a criminal experience which made criminals out of so many who were not naturally so. Who were the people getting caught in the maelstrom at the turn of the century? Altgeld gives us a vivid picture. Of the 7,566 persons locked up in the House of Corrections, known as Bridewell, 5,700 were male and 1,800 were female. Most were nonviolent offenders, and most were poor, with the majority being locked up for their failure to pay fines. Mixed among these men and women, however, were hundreds of children under the age of 18, 693 to be exact. There was one 8-year-old, 5 9-year-olds, 14 10-year-olds, 25 11-year-olds, 47 12-year-olds, 68 13-year-olds, 103 14-year-olds, and hundreds of 15 through 17-year-olds. All told, over 9% of the Bridewell facility was made up of children under the age of 18. The plight of these children outraged Altgeld, and he lectured about it at Jane Addams' Hull House, and his words inspired Addams and Lucy Flower and Julia Lathrop and other progressives to establish a better and more humane justice system for children. Their community organizing and coalition building led to the first children's court in the world and the creation of a separate justice system for children, one premised on rehabilitation and individualized justice, not on the crippling punishments and one-size-fits-all sentencing schemes of our adult court system. And the juvenile court was only the start of a remarkable run of child-centered reforms spearheaded by the Hull House women. Soon to follow were other universal reforms, such as the child labor laws, compulsory education laws, the construction of playgrounds, recreation centers, and parks for children, and pioneering work in the area of early childhood education. Who were these Bridewell boys and girls whose plight inspired this crusade for children? Who were these children who ushered into existence a new, uniquely American vision of childhood as a sacred period of human life, a period of wonder, creativity, and human potential? They were the sons and daughters of the poor immigrants in Jane Addams' neighborhood. They were Irish American, Italian American, Polish American, and German American. They were not black or Latino children. Blacks had just begun to stream into Chicago after Reconstruction. The problem of the color line, as W.E.B. Du Bois would later call it, when he predicted that race would be the major problem of the 20th century, had not yet begun to pervade the juvenile justice system. But it didn't take very long. In 1913, the Juvenile Protection Association reported that 1/3 of the women and girls in the Cook County Jail were black. A 1923 master's thesis from the University of Chicago School of Social Service Administration found that 16% of the girls in Geneva, the state training school, were black at a time when blacks made up only 2% of Chicago's population. A 1931 study of the St. Charles Reformatory for Boys found 25% of its residents were black. By 1946, the number had jumped to 30%, while only 4.3% of Chicagoans or Illinoisans were black. Instead of reducing the institutionalization of children, the juvenile court was facilitating it, especially if your skin color happened to be black. And if you walk into the juvenile court of Cook County today, as Angela did and Luis did earlier, you can't help but be struck by the complete absence of white children. Black and brown children fill the waiting areas on both sides of the court. And if you venture into the detention center, you'll see about 90% of the children are black or brown. The next largest percentage are Latino, and the rest are white, Asian, or other. Throughout the country, black children are disproportionately represented at every stage of our juvenile justice system. Although black youths make up only 15% of the total population, they represent 26% of arrests, 32% of court referrals, 36% of those who are charged, 41% of those detained pending trial, 46% of those incarcerated, and 52% of those who are transferred by judges. The incarceration rate for Latino youth is 60% higher than our white youth. And it's too easy to say that these disparities can be attributed to the fact that young people of different racial groups commit different types of crimes, because the statistics belie that. Black youths are more likely to be confined than your white counterparts for every offense group. Black males are 6 times as likely to be locked up in state correctional facilities for crimes against persons, 4 times as likely for property crimes, and an astonishing 30 times more likely to be locked up for drug offenses than their white counterparts. Instead of addressing this discrimination, several powerful U.S. senators and congressmen are urging us to ignore it. If their proposed federal legislation is passed, states will no longer even be required to monitor the disproportionate impact of our juvenile justice systems. Shea Bilchick, director of the Office of Juvenile Justice and Delinquency Prevention, was in Chicago last week, and he told the Chicago audience that the federal mandate, which requires that states confront and seek solutions to the problems of the color line, is the most in jeopardy. Why are minority youths overrepresented in the juvenile justice system? If the statistics don't convince you that the system is racist, perhaps some individual cases will. The simple fact that these cases have demonstrated to me is that the system, the juvenile and criminal justice system, simply do not value the lives of black and brown children the way they value the lives of white children. Black and white children follow a different course in our systems. For blacks, the course drives them deeper and deeper into the system. For whites, every effort is made to keep them out. Ask yourself, why is it that the word super predator was born out of several Chicago cases involving black youth and was repeated many, many more times in discussions involving black on black crime than in crimes involving white youth? Though my unscientific research needs to be verified, the word rarely, if ever, is used to describe the middle-class white children who have been involved in these horrible tragedies in our nation's schools. When Michael Carneal, a lonely and troubled white 14-year-old, opened fire on his classmates in Paducah, Kentucky, why is it that Reverend Jerry Falwell spoke out against the decision to prosecute this boy from a good church-going family as an adult? Why was he silent before when thousands of black and brown children were tried as adults? Were tried as adults and sent to adult prisons for far lesser crimes? Why has he been silent since? Ask yourself if the Winnetka police would have questioned one of their community's 7- and 8-year-olds outside of the presence of attorneys or parents in a high-profile child murder case. Would they have charged one of their children with first-degree murder when the only evidence was an alleged oral confession, which did not match the crime scene evidence, all of which pointed to an adult sexual predator? Wouldn't the Winnetka police have held a press conference telling the world they were certain that these boys committed the crime before even running tests on Ryan Harris's underpants? Would Chicago police have done these things if Ryan Harris were white? If the suspects were white? Why is it that children who live in public housing and carry drugs are prosecuted as adults, while children who sell drugs in Kenilworth and Hinsdale are not? Why is it that teenage bank robbers are not tried as adults in DuPage County when teenagers who possess drugs in the Robert Taylor homes are? All these examples may make you think the situation is hopeless. But actually, for the first time, I'm hopeful. And I'm hopeful because a sensitive, hardworking, and intelligent black man, a man who is not afraid to talk about issues of race in the juvenile justice system, the presiding judge of Cook County, William Hibbler, will soon take a seat on our federal bench. And I'm hopeful because hundreds and thousands of people, black, white, brown, yellow, red, women, children, Christians, Jews, and Muslims, locked arms and were arrested together in New York to protest the shooting death of a West African street predator, Amadou Diallo. And I'm hopeful because in the past year, in 2 high-profile juvenile court cases, prominent African-American attorneys have ventured into juvenile court, fought brilliantly for their clients, and made us all think and talk about issues of race and juvenile justice. We must continue to confront and try to tackle the issue of race in meetings such as this one. It is part of who we all are. We cannot sweep it under the rug. If we try to ignore it, the problem of the color line will continue to plague us throughout the next century, and we cannot afford to allow that to happen. Ultimately, however, I think that justice for children, especially minority children, will only come if we, like the progressives, think in terms of universal, colorblind solutions, solutions which come from within our communities, not from within our courts. Only if we all close our eyes and ask, how would we want our children to be treated on the streets, in the schools, in the courts, and in the station house? And only if we then demand that the children of the court be treated as if they were our own will we ever reach the high aspirations of the juvenile court's founders for justice for children.